I see it on now.
Excellent.
The following is paid programming. Welcome to Something More with Keats Boyd, certified financial planner practitioner.
Try that again. Not sure why we got a hiccup there. Did you have that hiccup too, Jeff?
What was the hiccup? The video?
The video?
The stalled for a
It had
second.
a little bit of a glitch. All right, here we go.
I thought you did it.
The following is paid programming. Welcome to Something More with Keats Boyd, certified financial planner practitioner and founder of Asset Management Resources, LLC, a registered investment advisor firm. We call it Something More because we like to talk not only about those important dollar and cents issues, but also the quality of life issues that make the money matters matter. Here he is, your fulfillment facilitator, your partner in prosperity, advising clients across the country, your host, J. Christopher Boyd.
Welcome, everybody. Thanks for being with us. I'm Keats Boyd. I'm here with Jeff Perry, and we have a special guest today, F. Keats Boyd III. I almost said Junior, which is our dad. But F. Keats Boyd III, he is the principal at Boyd & Boyd. What's your role there? President, CEO? How do you refer to yourself?
I usually use president, but
there you go. And if you don't know, Boyd & Boyd is a prominent estate planning law firm here on Cape Cod. And we've got some estate planning discussion to talk about. Some pretty significant recent developments that we're going to talk about to kick us off. Anyway, Keats, welcome back to the show. Thanks for being here.
Thanks for having me. It's good to be here.
Well, it seems like you had this case that you were talking about just this week that breaking news. And so we wanted to talk a little bit about that.
Right. It's an appellate court decision in a divorce case, which you'd think, well, how does that impact estate planning?
Yeah.
The principal issue in this case was when one of the spouse's mothers established a trust. And the question is that trust part of the marital estate to be equitably divided as a part of the divorce? And so the interesting part is that the court found that, yes, this trust was, even though it meets many of the requirements that normally in most states you'd say, no, that's outside the marital estate. There were certain factors that the court was looking at that said, yeah, we're going to include this trust. And so what this does is for estate planners, it makes it really important that you look at how you build a trust for somebody to inherit and make sure that they're not going to be losing some of that gift should they later have a divorce. So things like in this particular case, there was about $1.3 million worth of property, both real estate and investment type assets that were of a concern here. And the trust was built as a discretionary trust with a third-party independent institutional trustee. And that institutional trustee could decide whether or not to give anything to the daughter who was a party to the divorce. It also had something called a spendthrift provision, which means the creditors of a beneficiary aren't supposed to be able to reach into the trust and try to take assets away. So they're not assignable. And yet the court said, well, the way they worked with this trust, that there was a specific and enforceable interest in that trust, and so therefore it could be equitably divided. Now, the judge didn't say you have to take assets out of that trust and give it to your soon-to-be ex-husband. Instead, they said, well, you're going to get to keep the trust, but your ex is going to get more of other stuff. And so,
Keats, was this trust established before or after the marriage of the?
During the marriage.
During the marriage.
Yeah. And it was established in a way that they, many of the gifts it was established by the wife's mother. Right. And according to the lower court decision, much of the assets that were being used in the marriage came from the largesse of the wife's mother. They both had jobs, the divorcing couple. They both, contributed equally to the household. But they were able to do things and live a, quote, lavish lifestyle because that they were getting gifts from the wife's mother. And some of this was through this trust and through other methods. But it really made it so that the judge felt that this was something that was part of what allowed them to live the lifestyle that they had, and so therefore it was divisible, at least in the calculation of what is marital property. It was includable as marital property, and then the assets, again, as the trust that the wife it was inheriting was left for her.
But it counted
intact,
against
but
her.
it counted
in
against
the
her. Right.
division of property.
Right.
Interesting.
Right.
Seems counter to what the intent was.
Yeah.
To the purpose of that trust.
Right. And adding to this a little bit was the fact that the trust was a Michigan trust set up under Michigan law.
Right.
There were these conflict of law issues. How do we interpret that? But the court basically said, well, yeah, you were married in Michigan, but you lived in Massachusetts. You filed for divorce in Massachusetts. So therefore,
we're going to say our laws
apply in the divorce.
Was there something they did wrong in the way they did this to accomplish their efforts? Like, is there something they should have done differently that might have
there's
been more effective?
Two components to your question. Was there something they did wrong? At the time the trust was written, I would say no. They did it in compliance so that they get the right result based on the law when this trust was first established.
Yeah.
But can we do something differently now, knowing that the courts are moving in this direction? We saw this movement a little bit in the Fan & Steel decision several years back. I think it was 2012. That case was another divorce case where the appellate court said, yeah, assets in an irrevocable trust are divisible, and they were really going after it. The SJC overturned the appellate court decision. I don't know if in this case it's going to be appealed to the SJC or not.
Yeah.
But for now, it's
so the higher court in Massachusetts might
overturn
this.
Of this. Yeah. But again, it's a discretionary trust, which means the trustee does not have to give the beneficiary anything at all.
Yeah.
And it's for I think the difference here is this trust was essentially for the wife during her lifetime, and then it went to the kids, her kids.
Mm-hmm.
And I think if we had drafted this trust a little bit differently, so it was more akin to the trust in Fan & Steel, where the beneficiaries of the trust were a pool of beneficiaries. It was one of the spouses and the children concurrently, and the trustee had discretion to give assets out to anybody in the pool.
Mm-hmm.
I think that would have gotten a better result. And I think that's what would be the critical decision to make sure for planning going forward to protect from a divorce, at least for somebody divorcing in Massachusetts, that we have that concurrent pool of beneficiaries. That should probably avoid this issue.
I'd like to step back a little bit. Jeff, were you looking to say something?
I just had one more question. So she had no defined vested benefit? It was
the trial judge said, yes, she had a determinable, what was the terminology he used? A fixed and enforceable property right. But, based on what I'm seeing in the decision, and honestly, I haven't had the opportunity to read the underlying trust to confirm this, but it appears that the wife's interest was subject to the discretion of the trustee.
That's it's a very interesting legal question.
Yeah.
Well, let's step back to put this into some context. We jumped right into the thick of it with this interesting development and its potential consequence. Let's step back. When we talk about estate planning, we don't usually talk about divorce necessarily,
right?
But in this case, one of the things that you've been talking about over the last several years has been the additional importance. We often think about estate planning as, who's going to get my stuff when I'm gone?
Right.
Or can I avoid a tax or probate or some of these kind of various concerns that people have. But over the last several years, you've been talking about, hey, there's some potential impact for creditor protection for your heirs.
Right.
And how you set up your estate plan.
Yep.
And so, that's where I think this fits in to our conversation. Mm-hmm. Does this decision, for as far as you're, thinking right now, does it have some impact on the estate planning that people may have done with the intention of having creditor protection features for their heirs
Right.
from a divorcing spouse, as an example. One of the things that people want to make sure, if I die, I want my stuff to go to my kid, not their divorcing spouse per se.
Exactly.
So does this decision complicate that with regard to your personal asset trust provisions or the IRA inheritance trust provisions?
It can. It's a little bit. I think it might be a little bit fact dependent.
Too soon to say, perhaps, or is it?
No, I don't mean it that way.
Weeds.
I think you got to get into the weeds of a particular client's situation.
Okay.
All right. So, for example, if mom and dad set up a personal asset trust for their child, and that child does not have any children, the trust is written so it's a discretionary trust. The trustee can decide what, if anything, to give out to the beneficiary.
So it might fit very similar to
very similar fact pattern.
Yeah.
But does it if because there's no successor beneficiary or concurrent beneficiary, are we in the same fact pattern? The answer might be yes.
Sounds to me like you're thinking that perhaps these kinds of trusts, the personal asset trust, the IRA inheritance trust, that these might call for some adjustment, some revision in terms of how that discretion works. If there's a second generation or a third generation,
if there's not another generation, I think
or if there is, will you include that generation as part of the immediate beneficiaries of that?
On the personal asset trust, they're definitely included.
Okay, so you might be protected anyway.
I think you're protected there. The IRA trust, I believe they're included there as well. So if you've got multi-generational descendants, your children and your grandchildren
on this issue,
all within the same bloodline. So let me say it differently. If you can have children and grandchildren, but maybe one of the children doesn't have any children.
Yeah.
That IRA trust may have a problem under this decision for the child who does not have children.
Okay.
Right. For the situation where you have a child who does have children, the PAT and the IRA trust, I feel, aren't going to be negatively impacted by this because the pool are all concurrent beneficiaries. It's up to the trustee to say, am I going to give it to the child or am I going to give it to the grandchildren? Am I going to split it up amongst them?
Yeah. And your perception would be the court would look at it differently than in this case where they said, well, it's all for you either way. So the division of property is going to account for that.
Exactly. Yeah. Exactly. So I think, and that doesn't mean that we're not going to be looking at this with a really magnifying glass to really look at the details, the nitty gritty of it. Yeah. I do know in all of the trusts, it does say that we're supposed to kind of emphasize the interest of the child as opposed to the interest of the pool. And we may want to change that. We may want to take that language out to say that we're not going to emphasize anybody. We're just going to say it's for the pool because we don't want a court to latch on to that emphasis and say, well, you're supposed to be the primary beneficiary. You're supposed to be the one who's getting the benefits. So we're going to be able to interpret that against you.
That could have some consequence though.
Right.
Yeah,
it could.
Now, who typically in these trusts is the decision maker about?
Right. The trustee. Now, who's the trustee? Very often it's the child.
Meaning, in this case, mom and dad set up this trust so that they would protect their child from a divorcing spouse with the inheritance they might receive. So that's the child, even though they're an adult in this case. And we're talking about a third generation, the grandchild in this case as well. So you're saying the child is often the trustee, the manager of the trust, who can decide whether or not it's going to go to themselves or go to their children.
Okay. And if that's the situation where they can make that decision on their own, who's going to get it, and you take away, hey, you're supposed to emphasize yourself from the language of it, I don't think you're hurting most beneficiaries.
What I remember at times you've talked about this notion of a trust protector being involved in these kinds of documents where someone can be called up from the bench, so to speak, not the legal bench, but the from the batting bench, I'm thinking here. But so there's somebody been called up and say, oh wait, you got to step in and protect from some court requirement or
Yep.
whatever it might be.
So for
Does this apply in any of this?
It could.
Yeah.
So for example, if we have somebody who has passed away and we've got a pat out there, and the language saying it's for
personal asset trust.
We've got an existing irrevocable trust that is a discretionary trust for the child of the donor, and concurrently for the grandchildren of that, the children of that child, the grandchildren of the donor. And the language says emphasize or prioritize the interests of the child of the donor over the interests of the grandchildren of the donor. And then that child goes into the divorce court and this decision isn't changed, it's still out there. Is it possible to tweak that? A trust protector could do that. And it's probably a good idea to do it before we think we might end up in a divorce court. So we've got that change made ahead of time. There's a couple of ways we can do it. Trust protector would be one way. If we have decanting authorized in the trust, which was a decision thanks to the Kraft family in Massachusetts, we have case law saying we can take the assets out of one trust and
pour them into
another trust
vehicle, and just essentially it's
so we can effectively amend the trust through this process of taking out of one document and moving them into a different document. So the
new document has the language you want.
Exactly. So we could do that as a process. If all the beneficiaries agree, most of our documents allow for the trust to be amended.
Okay.
So that's something that is not in the state trust code. It is in the Uniform Trust Code, and many states like California, Florida, which have adopted that Uniform Trust Code that say, yes, the beneficiaries can all agree. They don't need to go to court to amend. Going to court is expensive. I mean, of course, we can do that here in Massachusetts. We can always go to court if everybody agrees and amend the trust, but that's an expensive option.
Try to avoid that option.
Right. So, we can amend by agreement, amend by court, amend by trust protector, or if decanting is in the trust, amend by decanting.
Yeah.
So all of those will give us vehicles after the trust is irrevocable to fix these kinds of issues. And you want to do that prior to any problem, whether it's a creditor problem or divorcing spouse problem. One of the concerns I have is, while this is a divorce decision, will this logic be used by a creditor to say, hey, that beneficiary is the sole beneficiary.
That's what I was wondering, right?
Assets out of the trust.
Yeah. So if it works in one instance,
will it work in another? And so that, this decision has significant ramifications to estate planning when we're planning for asset protection of future generations.
Jeff, do you have anything else on this particular aspect of this? Otherwise, I'm going to transition a little bit.
No, go right ahead. Keats answered my question. I was wondering if the spendthrift provision is in jeopardy, but he answered it with a typical lawyer answer, maybe.
I'd say no. Spendthrift provisions, I don't think this impacts the spendthrift provision per se, because a spendthrift provision says the creditors of a trust can't be assigned the interest of a trust. So this decision, I don't think impacts that at all. What I think it does is it says a creditor could go into a court and ask a judge to order the beneficiary to remove assets under this kind of a theory, to say that, hey, you're the primary beneficiary. Satisfy this judgment because it's primarily for you. It's not for other beneficiaries. Now, who's the trustee? Well, if the beneficiary is also the trustee, they're going to be subject to that court order. So we don't want that. That's when we usually pull in a trust protector to remove that beneficiary as a trustee and replace them with somebody else. So the child has no say in it. It's done to them and for them, but it's not something that they did to cause inability to comply with a court order. But there's the spendthrift provision, I feel, is still intact. It's just the logic of this decision to say that because it's primarily for one beneficiary, it should be somehow reachable. Will this decision try to be expanded? It doesn't say this, but that's
the same rationale, right? I mean,
right.
Yeah. Makes sense. right, let's transition briefly. This time of year is a common time of year, Keats, that you do market to the public about educational seminars, spring and fall type of thing. And I noticed you're already out giving seminars. The month has barely started in September, and you're
We've
out
already
there
had
already.
a couple of sessions. So we did one at Wauquasit. We had one at the Daniel Webster the other day. We've still got several events left. So if anybody wants to learn some of the basics of estate planning, what are the common goals? What are the usual techniques? What is a personal asset trust? What's an IRA inheritance trust? How do these assets, how do these planning vehicles protect your wealth? And so
it's interesting because you say the basics, and in reality, this does cover some of the basic fundamentals, but you get into strategy to some extent with these kinds of techniques as well. So it does get, it's substantive. Let's put it that way. It's not, fluff.
Right. It's a 2-hour intensive masterclass on.
There you go. Yeah, it really is
on estate planning theory and
where we're at today. What's one of the best techniques?
One of the big things,
arguably,
one of the big things we're seeing is a shift. I think a lot of people are saying, "Oh, estate taxes. I'm a little concerned about that. Massachusetts still has a relatively low estate tax threshold. You got to plan for that." Income taxes really are the new estate tax. And we're looking at it from a number of perspectives. One, wills, probate estates, and most trusts are going to be taxed at the highest tax bracket of 37% when income exceeds about $14,500, a little less than that.
Not a big threshold
it's
to reach.
Very,
and that includes capital gains.
Capital gains are at 20% when it's $14,750, I think, is the threshold.
Yeah, so you're pushing, we're pushing everything into these higher brackets.
Right. And then we're looking at the Tax Cuts and Jobs Act going away in a couple of years.
Yeah, what is that? 2026 it's ended?
Yep.
Yeah,
right.
So
it's gone.
Between now and 2025 is all the time you got.
And so that means we're going to see a 39.6% bracket.
And reach it faster.
Right. Because brackets are more compressed under the old law.
Yeah.
And so while they will be, adjusted for inflation, they're not going to be anywhere near where they are right now for individuals. A married couple, it's north of 600,000. For a single person, it's over 580,000 to hit the high bracket. It's going to go down. And all of the brackets go up about 2 percentage points.
Yeah.
So, we're looking at a major tax increase in 2026.
And for most individuals, you give up what was the heightened standard deduction that was double, I think, what the old standard deduction was.
Right.
So
you
might have some itemized deduction.
The SALT limitation will come back for people who have multiple homes or homes in high tax states. The income tax, that whole thing will come back. That will benefit some taxpayers. But there are workarounds for most of those already built into the law. Massachusetts passed a workaround to allow for SALT deductions through pass-through entities. There's a number of different things that have been done to try to work around that SALT limitation. So it's I don't know that it's going to be that much more favorable for people.
Well, just to in terms of all that, I mean, to prognosticate for a second, it doesn't seem likely that they're going to reinstate or extend the Tax Cut and Jobs Act when you look at the degree of debt that is being accumulated in DC. I mean, Jeff, do you have any thoughts on that either? I just it doesn't seem likely to me.
No, and we haven't even discussed yet Social Security and Medicare, the challenges those two entitlements face. So with everything
facing within a decade, so
even Republicans are going to have to, we're all going to have to face the facts here that something's going to change. It might not go back. There may be a whole new scenario, a whole new bill that has some third option available, but I think it's likely that higher income tax at the federal level on the horizon.
Right.
Probable, yeah.
So anyway, we get
So
into all of
getting
that
off
and
the
some of the
topic,
strategies that we can use to avoid high taxes in the seminar. And it's really so that when you pass away and your trust becomes irrevocable, how can we avoid being taxed at 37 or 39.6% at a very low level of income? There's some very simple things that we can do that we build into our estate planning documents, and just a question of knowing the tricks and knowing the secrets so that you can avoid some of these problems.
Yeah.
So and we go into all of those.
These are things you should entertain if you haven't updated your estate plan in a few years. A lot's changed over time. Additionally, even if you have, if you have an estate plan, it might be worth reviewing. But if you don't have an estate plan, or it's been a while since you had the kids at home, and your will type of thing, and it might be the time to update.
To revisit.
That's a common scenario as people move toward retirement. They start recognizing my plan's out of date. I need to update it. That's really who's going to benefit most from this kind of a talk, or someone maybe who's already taken a stab at it, but things may have changed.
Right.
I was talking to someone the other day, and they're like, "Oh yeah, I did an estate plan 10 years ago. I'm good."
Yeah, that's too long ago.
That's a long time. Yeah.
We're seeing important legislative or case changes coming through at a rate of about one per year.
Yeah.
One of our handouts summarizes all of the changes in the law for about a 15-year period. And there's a lot. It's hard to fit on one page.
Yeah.
But there's an awful lot that's out there, and your plan needs to adapt and adjust. And then, of course, you may have changes in your family circumstance. And so you need to incorporate those. So it's really something people need to not just set it and forget it, stick it up on the shelf and dust it off once every 10 years or so. They really should review it every year and probably need to make some tweaks once every 3 to 5 years.
Well, I think I want to encourage everyone to take a look. If you haven't been to one of the Boyd & Boyd estate planning educational talks in the past, or if it's been a long time, you might benefit from checking it out.
Right.
You can find information about that, I imagine, on your website, Keats?
Yeah, there's something on our website, boydandboydpc.com, on our seminars page, but there's also something where if you're interested in making reserving a seat at one of the various sessions that we have left, you can go to uyoursvp.com and enter code QUXRUF. That's again on our website too at boydandboydpc.com.
All right, best bet is to go to their website, Boyd and Boyd, spelled out BOYDAND which is a little bit confusing sometimes, but pc.com, and you'll find all about it. And Keats, thanks for being with us to keep us up to date. Thanks
for having me here today. Good to go over this stuff.
And until next time, keep striving for something more.
Thank you for listening to Something More with Chris Boyd. Call us for help, whether it's financial planning, portfolio management, insurance concerns, or those quality of life issues that make the money matters matter. Whatever's on your mind, visit us at amrfinancial.com or call us toll free at 866-771-8901 or send us your questions to radio@amrfinancial.com.
You're listening to Something More with Chris Boyd, Financial Talk Show.
Asset Management Resources LLC and J. Christopher Boyd, CFP, provide investment advice on an individual basis to clients only. Proper advice depends on a complete analysis of all facts and circumstances. The information given on this program is in the nature of general financial comments and cannot be relied upon as pertaining to your specific situation. AMR LLC cannot guarantee that using the information from this show will generate profits or ensure freedom from loss. Listeners should consult their own financial advisors or conduct their own due diligence before making any financial decisions.